Third reading.
Call on Government Order of the Day number 9.
Enforcement Amendment Bill, second reading.
Mr. Speaker.
The Honourable Simon Power.
Mr. Speaker, I move that the Trademarks, International Treaties and Enforcement Amendment Bill be now read a second time. Mr. Speaker, this bill was introduced by the previous government and amends the Trademarks Act 2002 with two clear objectives in mind. The first objective is to ensure that procedures for registering trademarks are aligned with international standards to minimise regulatory and business compliance costs associated with the protection of trademarks. The bill ensures that the trademark registration procedures conform to the international standards set out in the Nice Agreement. It has been a long week. The Nice Agreement concerning the international classification was a nice agreement. The Nice Agreement concerning the international classification of goods and services for the purposes of the registration of marks, and Singapore Treaty on the law of trademarks. Joining these WIPO treaties is an important step in the process of harmonisation of our regimes for the protection of trademarks. To further the single economic market with Australia, the Ministry of Economic Development is also working with IP Australia to further harmonise our respective trademarks registration procedures not covered by the Nice Agreement and the Singapore Treaty. The bill also amends the Trademarks Act to facilitate the implementation of the international registration regime for trademarks provided for by the so-called Madrid Protocol. The aim of the Madrid Protocol is to reduce business compliance costs associated with registering trademarks in overseas jurisdictions. Joining the Madrid Protocol will provide New Zealand businesses with the opportunity to have their trademarks protected in up to 84 countries by filing one application in English with the Intellectual Property Office of New Zealand and paying one fee. The second objective of this bill is to reduce the trade in New Zealand of counterfeit, trademarked goods and pirated copyright works. This is particularly timely legislation as we approach the Rugby World Cup, and with it all the economic opportunities for local producers of merchandise. Counterfeiting and piracy affects the profitability of legitimate businesses, undermining productivity and threatening the jobs of the many honest and hard-working New Zealanders. The bill clarifies that customs officers are able to seize counterfeit goods and pirated works at the border and undertake investigations to gather evidence to enable importers of counterfeit and pirated goods to be prosecuted. Furthermore, customs will be able to require a person connected with the importation of the goods to produce documents or require them to appear and answer questions related to those goods. The bill also creates a new enforcement role for the Ministry of Economic Development under the Copyright and Trademarks Acts, enabling so-called enforcement officers to seek and gather evidence to bring criminal prosecutions against counterfeiters and pirates. Enforcement officers will also have a limited non-warranted search power to enter public places and businesses open to the public to examine and seize illicit goods being displayed for sale. At this time, Mr. Speaker, I would like to thank the Foreign Affairs, Defence and Trade Committee for its consideration of the bill and for its sensible recommendations. These include the insertion of a new Clause 13A to clarify Section 96(1) of the Trademarks Act, which provides for no infringement for certain continuous use of an unregistered trademark. The committee also recommended changes to Clause 22(A) governing the appointment of the Commissioner of Trademarks and Assistant Commissioners to align their functions and powers to their counterparts under the Patents Bill. MED enforcement officers are also given an additional investigative power to more closely align them with their counterparts in customs. The committee recommended that new Section 134V1 be amended to give the courts the authority to order seized items found to be infringing to be forfeited to the rights holders for consistency with the general provisions under Sections 128 of the Trademarks Act and Sections 134 and 202 of the Copyright Act. Mr. Speaker, this bill recognises the importance of trademarks as an essential marketing tool for businesses so that consumers can recognise their products and services. By providing protection against the unauthorised use of trademarks, the government is creating incentives for businesses to invest in quality products and services. Mr. Speaker, I commend this bill to the House.
The question is